Afternoon, colleagues. I hate to interrupt, but I would like to get on to panel 3. It's fair to say that we've had a rich and robust discussion on the symposium so far, and it's now my great privilege to introduce panel 3, which will be dealing with adaptation, mitigation, and loss and damage. My job is a very small job, which is to introduce, in fact, the chair of the panel, Professor Ordor, who is a Steiner visiting professor in human rights for the spring term. She's a law professor and director of the Center for Comparative Law in Africa at the Faculty of Law, University of Western Cape Town. And Professor Ordor's work explores issues of law and development from various perspectives that demonstrate the interconnectedness of development processes and laws that govern them. She has held academic positions at the Nigerian Law School and visiting research positions at the African Gender Institute, UCT, as a visiting associate, and at the Johns Hopkins University Institute for Policy Studies, Center for Civil Society Studies, Baltimore, in 2003 as a senior international philanthropy fellow. She is an international fellowship alumna of the American Association of University Women and editor of the Journal of Comparative Law in Africa. So Professor Ordor, I'm going to turn it over to you.
Okay. Thank you very much. Do I use this or the?
Oh, actually, I think that mic should be fine.
Okay.
That one should be fine, yeah.
Yeah, thank you, Charles. Well, good afternoon, everyone. We are in the post-lunch session, and panel 3 is on adaptation, mitigation, loss, and damage. And I'm so pleased to be in a room with such distinguished people, but even to be chairing or moderating this session with a panel of very eminent colleagues around me. And I noticed from the details that most of the people on this panel, and I believe there's someone online. Is there? There was supposed to be someone connecting remotely. Maybe we should. Okay. Are they? Okay, thank you. So I noticed that most of the panelists live in countries other than their birth country or their home country. And I wondered whether that has anything to do with climate change-induced migration. And if it does, then this is a very timely panel. We need to be looking at adaptation, migration, loss, and damage. So it's my privilege to introduce the members of this panel in the order in which they appear in the program that you received. To my extreme right is Professor Dalindyebo Shabalala, who is a professor of law at Suffolk University Law School, but also has a joint appointment as an assistant professor of international economic law in intellectual property at Maastricht University in the Netherlands. Professor Shabalala's research focuses on the interaction of intellectual property law, especially patent law, with the rights of indigenous peoples and climate change law. So quite a punch that you packed there. He was all very topical issues. He was also managing attorney of the Center for International Environmental Law's Geneva office, where he directed the Intellectual Property and Sustainable Development Project. He is the vice chair of that center's board of trustees. And online we have Professor Oluwatoyin Adejonwo, who's a senior lecturer in the Department of Public Law, Faculty of Law, University of Lagos, an honorary senior lecturer at Dundee Law School, University of Dundee. She recently visited the Faculty of Law, University of Stellenbosch, as a visiting scholar and as a guest lecturer in the postgraduate course on sustainable development law, which I have been the external examiner for in the past. And she has also been visiting at the Center for Human Rights at the University of Pretoria Faculty of Law as a guest lecturer for the Human Rights and Democratization in Africa program. Dr. Adejonwo is the founding director of the Center for Climate Change and Sustainable Development and a solicitor and advocate of the Supreme Court of Nigeria. She has also at various times consulted for international environmental organizations, including the Heinrich Böll Foundation and the Federal Ministry of Environment. Dr. Adejonwo serves on the Committee of Experts providing legal advisory and technical support on climate change to the Department of Climate Change of the Federal Ministry of Environment. And she holds a Ph.D. in International Environmental Law from the School of Law, University of Dundee, where in her alma mater, where she is now also an honorary senior lecturer. And to my right here to my immediate right, is Angela van der Berg, who is the director of the Global Environmental Law Center at the University of the Western Cape in South Africa, the Faculty of Law of that university. She also holds the position of Associate Professor in the Department of Public Law and Jurisprudence. And Angela obtained her joint PhD in Law and Development from Tilburg University, the Netherlands, and Northwest University in South Africa in 2019. Angela's academic experience falls in the domain of public law, specifically international and domestic, mainly South African environmental law and climate change law, constitutional law, urban law, as well as public governance. Angela's current research focuses on the global dynamics of environmental law and governance in the pursuit of more sustainable, resilient, and climate-just futures. Angela provides legal consulting for UN Habitat on an ad hoc basis, and in November 2023, she was invited to serve as part of an expert committee to advise the African Union Committee of Experts on the rights and welfare of the child on a study related to climate change and children's rights. Very nice to have you, Angela. And online, I believe also is Funmi Abioye, who was an associate professor of law in the Department of Jurisprudence at the University of South Africa, from where she transitioned about 2 years ago to the University of Saskatchewan College of Law, where she is now a sessional lecturer. Funmi Abioye has been teaching in this field of environmental and climate change law, as well as other fields for the past 10 years. Her interests include various fields of international law, rule of law in Africa, good governance, and legitimate leadership on the continent. She has published successfully and widely in these fields. Funmi Abioye is an admitted solicitor and barrister of the Supreme Court of Nigeria, where she served as counsel for 5 years. And Professor Abioye is an editor of the Comparative and International Law Journal of Southern Africa, and that is where she was for 14 years at the University of South Africa before she relocated to Canada. And then, last but not the least, to my immediate left is Professor Olanrewaju Fabohun, Professor of Environmental Law, and who was the former Vice Chancellor of the Lagos State University. Professor Fabohun lectured at LASU, the Lagos State University, for 19 years at both undergraduate and postgraduate levels before joining the Nigerian Institute of Advanced Legal Studies in 2009. Professor Fabohun has served as consultant and task leader for the United Nations Environmental Programme, the British Council, the European Commission, World Council on Genetics, University of Nottingham, the Harvard Medical School, the National Judicial Institute, and several state governments, among others. He is also an external examiner and assessor for a number of programs in universities in Nigeria, South Africa, and in the Netherlands. Professor Fabohun is also on the board of the Environmental Law Research Institute and is a founding member of the environmental law of that institute, and also of a nonprofit organization for applied environmental research and policy analysis. I think I'm in right company, and what is not here is that we are well known to each other, and in fact we interacted in September at the Nigerian Institute of Advanced Legal Studies, and it's a privilege to have you on this panel, Prof.
Thank you.
All right, so I think we're going to kick off with each person has 10 minutes to speak. And I listen intently. When I listen, I don't often smile, so I've been told. So if you see me really smiling sweetly, it means it's a time to wrap up.
I like that.
That's the nicest way I can think of doing it. So can I ask, Angela, would you like to start? and speak
I
to
can
your
start, yes.
topic here. Tell us what it is you're speaking to and then speak to it.
All right. I have some slides. There we go. Okay, so I am speaking today on legal pathways and stumbling blocks for climate adaptation and mitigation in sub-Saharan Africa, and I'm focusing on South Africa, Kenya, and Nigeria. I'm very aware that there are colleagues in this room that may know much more than I do about the policy and legal frameworks in Kenya and Nigeria, so I really do welcome any constructive criticism or input. This is a developing paper. So I'm not going to, is it moving? Oh, sorry. I'm not going to speak about my whole paper today in the interest of time. I'm just going to focus on the last aspects where I really do compare the different legislative policy frameworks, the executive decisions or structures that exist, and then judicial responses to adaptation and mitigation. Just touching a little bit on why I chose sub-Saharan Africa and why I chose these three countries. I think it's well known that the entire African continent is perhaps the most vulnerable to climate change, as we've reiterated many times throughout the symposium. But sub-Saharan Africa in particular really is more vulnerable if we look at the continent as a whole. If we look at these three countries, they do face similar climate risks, albeit to varying degrees. Their significant impacts are with drought, which of course leads to food insecurities, water insecurities, and then irregular rainfall, which leads to flash flooding, which destroys property and homes. There are also economies in transition, but they have stark income inequalities, which really exacerbates the impacts of climate change, especially on the poor. They have similar legal systems based on the common law. They, for example, are democratic societies. They have a constitution with a Bill of Rights that enables access to justice through the judiciary. There's also a similar division in power. It's a devolved legal and governance system. So I thought it would be interesting then to look at the different avenues in law. So when I speak of legal pathways, I'm looking at just what is the legislative and policy framework. Are there framework legislation? Is there sectoral laws? Do they have adaptation and mitigation plans, for instance? Looking at executive or institutional structures, are there special structures to govern climate change? Have they changed governance processes? Were there any executive orders, the declaration of a climate emergency or disaster, for instance? And then, of course, judicial responses, looking at different judicial responses for climate litigation in these countries, whether through judicial review or judges making declaratory orders, the granting of interdicts, and to some extent, particularly in South Africa, the role of judges in judicial activism. So I unpack this theoretically in depth in the paper. There isn't time for that now. So I'm just going to jump then into the three countries and try and give you an overview of the law and policy frameworks. So what you'll see on the first slide is that South Africa has been involved in developing policy for climate change from about 2011 with our Climate Change Response White Paper. And then between 2011 and 2020, it was a little bit dormant, only starting again in 2020, but particularly developing energy strategies, so focusing more on mitigation over adaptation. We only passed a national adaptation plan, I think in 2018, could be 2019, but it's quite recent. And our climate change bill has not been enacted yet. That process started at least 5 years ago. We still do not have a National Climate Change Act or framework regulation. We do, however, have a Carbon Tax Act. There's a lot of controversy surrounding this act. It intends to implement carbon taxes in phases. A lot of criticism because certain industries are excluded from paying carbon taxes, like Eskom, for instance, our main power producing entity, and so forth. And something else that I think is interesting is the carbon tax is 120 Rand per ton. That is around $6 per ton, the taxes that are paid for emissions. So not really decentivizing, I think, from a financial standpoint. Then What I can tell you about the strength of our law and policy, so we are late in the game. If we look at legislating for adaptation, particularly in our country, we focused on mitigation a lot, and that means that adaptation is being regulated on an ad hoc or incremental basis. And we're now in sort of the initial phases where we have an adaptation plan, but we need to implement that. So any adaptation policy we have, it's too early to really tell if there are any measurable or tangible differences towards adaptation in our country. We do see a strong political commitment towards ambitious climate action. If you look at our updated NDC, the country aims to be net zero or carbon neutral by 2050. And we intend to incorporate our NDC into our Climate Change Act when it is passed, which means that will be a legally binding instrument then, our NDC, which of course opens up the floor for litigation even in the context of our NDC. Not many countries, at least from what I can gather in Africa, do incorporate the NDC into legislation in this way. The climate change bill, when it comes into effect, will also create sectoral emission targets. But again, sectors have been left out. There's questions surrounding that. So that again will potentially be a stumbling block for implementation. What is interesting is that our net zero goal is to be carbon neutral by 2050 is not actually in legislation, it's in policy. So leaving room for then debating how binding that goal is. If you look at our institutional structures and mechanisms, we have the existing ones, so the Department of Environmental Affairs and Fisheries, but then our climate change bill aims to enact a few new governance structures, one of which is the Interministerial Committee on Climate Change, aiming to ensure integration, mainstreaming, and coordination of climate adaptation and mitigation policies. And then we have the Presidential Climate Change Coordinating Commission, which is situated in the presidential office, aiming to provide advice on adaptation and mitigation. And I think one of the strengths in that commission is that it includes representatives from government, civil society, and the business sector. So it's poised to offer a balanced and inclusive advice, reflecting a broad spectrum of interests then in the implementation of our policies. So it looks, at least on paper, that we will have an elaborate system to really ensure coordination and mainstreaming of climate governance. But as has proven true in other domains in South African law, is these mechanisms are all in the national sphere of government. They tend to work in silo. Climate change is still seen to be a climate change siloed issue. It's not really taken up to some extent in energy, but it's seen separate, for example, from planning or from very green environmental issues. So that will remain a challenge. If you look at our judicial responses, according to Southern Centre's report, there are 9 cases. We're expecting much more. I've chosen to highlight 4 cases. So the first is the Vukani environmental justice case, or the deadly air case. So this case was about air pollution in the Highveld Mpumalanga priority area, not necessarily about climate change, but what makes this a climate change case is that the court looked at climate change principles or international principles in environmental law, and particularly looked at the principle of intergenerational justice or intergenerational equity, and said that that principle is a rejection of short-termism in our political cycles, and that politicians can no longer think of climate change as a future issue. It's linked to air quality and air pollution, and that air pollution in that area will exacerbate climate change for future generations. The court also very controversially recast Section 24, so our environmental right, as immediately realizable. It's currently a socio-economic right, which is progressively realizable. So a very controversial case, but the judge really played an activist role. It is, however, on appeal. Then we have the case against Shell for for seismic exploration in our coastal areas. There, the court looked at the role of marine life and how it would be impacted by Shell's activities. They also looked at indigenous communities and fishing communities and said that the seismic exploration would really impact negatively marine life, but also the cultural values and principles of the communities using that marine zone to fish. And it granted the interdict against shell to stop them essentially from the seismic exploration. Then the last two cases, Earthlife and Kanisa, are about the granting of coal-fired power stations. The first one is interesting. It's in the High Court, where the court read in climate obligations in our existing framework environmental legislation. So this is now in the absence of framework climate legislation, saying that an environmental impact assessment must include a climate impact assessment. So it stopped that coal-fired power station from progressing. The second case was, a part of it was in the Water Tribunal, and again, the Water Tribunal read in the National Water Act. They read in climate commitments and said that the phrase in the Act, any relevant consideration, includes the impact of climate change on water security in the region. So very progressive judgments we see in South Africa. So the strength here, I would say, really lies in, we don't have national framework legislation for climate change, but in the absence of that, I'd say that we have a strong active judiciary. And these judgments, particularly the Thabameti and Kanisa cases, have led to legal reform. There are now new regulations where environmental impact assessments must include a climate impact assessment, for instance. It also, in some of the cases, like the seismic blast case, you see that the courts are prepared to use human rights approaches and to integrate international climate change principles in the protection of human rights as well. So some of the stumbling blocks, and this you'll see is so for all three countries that I do discuss, is the lengthy procedures of litigation. Some of these cases were brought to court 10 years, and only after 10 years. And vulnerable communities don't have the luxury of time to wait for courts to decide these matters. And then, of course, you want me to stop?
No, just wrap up after this, and then we can do the countries next.
All right.
We'll come around a second time.
Oh, okay. All right, I'm wrapping up for now.
You look puzzled. Yeah, because I'm going to do this. We're going to do a second round, and then when we come to your next round, we'll look at the other countries.
All right.
All right.
Those are shorter, though. But
Are they shorter?
They are a bit shorter, yeah.
Okay. So thank you very much, Angela. I'm sorry that I might have jumped you earlier. So I think I'm going to go back and use the order on the list so that we don't have. So which means Professor Dalindyebo, Shabalala, we listen to you now. And then, yeah, we'll take 10 minutes of what you have to say, but there will be a second round. So feel free to break it up into two, okay?
Thank you. So I want to first do some disclaimers. So the attitude I'm taking, the approach I'm taking, is built around my experience in the negotiations at the UNFCCC, both during COPs and during the intersessional discussions. I come at it from somebody who has spent almost the entire time in environmental work looking at the issue of technology transfer and technology cooperation as one of the ways in which to address this issue of mitigation and adaptation, and I've been highly focused on those negotiations. And so what I'm putting forward reflects some of that experience, and some of the solutions I'm putting forward reflect that experience. It also suggests that, even though I've been working on human rights issues since I started working in this area, a certain, I think, naivete to the utility of human rights that I think we should take into account when we consider what I'm about to talk about, and the undeniable problem of intellectual property is a highly technical area, which has historically lived in a silo, and since the advent of the TRIPS agreement and WTO has become increasingly important, but as I think Charles has mentioned, has been a problem in integrating with other regimes in international law. And so, there's a bigger project on systemic integration, I think that implies. But I'm not going to be doing that here. So, when we talk about mitigation and adaptation, and in particular with respect to Africa, the key question is, on mitigation, how is Africa to develop? How are African countries going to develop? Given that the historic pattern of development has been a primarily fossil fuel production and consumption development pathway, how are African countries going to develop by avoiding that pathway? The solution that at least we live in, besides certain behavioral changes, is going to be technological. To the extent to which African industries adopt technologies, and the extent to which technological goods that are less emissions inducing are consumed by African populations, and the extent to which agricultural and food are consumed that is produced in a less emissions producing way, those are going to be utterly and totally necessary to sort of the mitigation goal. And then on the adaptation side, of course, the entire project of adjusting to the impacts of climate change is going to require access to medicines, to various other kinds of technological solutions, housing, heating, cooling, all of that to those aspects of development. And so I've always believed, and I think many of us who work on climate change have believed, that the fundamental issue at the core of the negotiations is going to be not just the commitments to take actions, which are necessary, but the means to take action, and who will be able to access those means to take action. So my critique then is that, I adopt, I think, Professor Mbenga's idea and others, that historically speaking, we've relied on common but differentiated responsibilities and even sort of a broader development framework to provide us with a regulatory framework and a bargain for addressing that technological gap. The idea being that, yes, we have common but differentiated responsibilities. As Professor Mbenga pointed out, there are some historical responsibilities. And we've built an idea that the responsibility to act first goes with industrialized and developed countries. They will demonstrate the means and the manner by which you can decarbonize, and by doing such demonstration, provide a pathway for developing countries, both middle income and least developing countries, to follow in that direction. And in doing so, there will be this bargain that those technologies and financial support will be provided or enabled for access by developing countries. Under the traditional framework that comes from the new international economic order, that comes from the Stockholm Declaration, there is this dual justification for dealing with this at the level of the states. There is this deindustrialization argument that came out of the NIEO and modernization theory, that industrialized countries, when they were colonizers, deliberately deindustrialized developing economies, and so then there is a reparation approach, and there's a need for reparations, a need to transfer technology and transfer finance as an obligation to correct for that historical harm that has made it difficult for the countries to develop. That came out of NIEO, continues to be a strain in which the D77 makes its arguments even in the climate arena. The other one is a transactional bargain, and the one that I just talked about, which is developing countries have said, we will take action for this common problem if we get access to the technology, Part of the bargain was that in order to convince developing countries to come to the table, Stockholm being the first example of that, but further on, we need to provide them an incentive. Why would developing countries come to the table in Stockholm otherwise? That they were going to be guaranteed as part of a bargain access to technology. My argument is that both those justifications have failed, The fairness, equity, reparations argument has failed in the context of the climate negotiations, and the transactional bargain has failed at the climate change negotiations. And my argument is the reason that has failed is that we've not been able to get around, one, the mercantilist problem, which is, why would firms in developed countries provide technology to potential competitors in developing countries, It used to be Japan, it used to be Taiwan, it used to be Korea. now it's China and Brazil and India, and they've seen it happen over and over again, and there's this question of the rational behavior of firms in those countries, right, makes it such that they don't see any interest in doing so because there's a competitive problem. Right? They see that they are essentially funding their competitors. And in particular, you can see this because those of us in this room, for the most part, are the beneficiaries of the elite development of economic privilege that has happened over the past 20 years. We've been able to benefit from that, but the vast majority of populations in all our countries remain poor and a low human development index. And yet, when we look at the level of each country, some countries look really good, right? And so to that extent, that creates a real problem. When the US sees itself competing with China, that makes it so that there's no way they can consider China or the population of China as deserving of assistance or aid. This becomes true for Nigeria, this becomes true for South Africa, and that creates a real problem. The other thing that I think we can say, and the reason it failed, isn't just the murkiness problem. It's, frankly, and as an African, I hope I can say this, the fundamental failure of distributional justice in our own countries. To the extent that you're looking at the inequalities and the inequities in our own countries, and the extent to which we see who has captured the benefits of development, it has not necessarily been, right, the most poor and the most vulnerable and the most needy and the most underprivileged parts of our societies. And that justifies an attitude on the part of the industrialized countries providing ODA or providing finance or technological support to say, if we provide such support or provide such money, where's it going to go? Right? We want, and it justifies them seeking control, using institutions like the World Bank and the GEF, where there's more institutional control, and it makes it harder to argue for, I think, the fairness and equity claims that we are making, which I think, frankly, are the strongest claims that can be made in this environment, in this arena. The fairness and equity claims, I think, still can be really strong. So how do we restore this claim? And how do we restore this claim? And again, remembering that this is a solution that comes out from a very specific problem of technology transfer. So finish the sentence and then,
finish
which is, and the sentence is, we need to take a human rights approach, right? A human rights approach to this is one that focuses not at the level of the state and the obligations states owe to each other, but the obligations that the state owes to its most vulnerable populations and that other states owe to assist that state in meeting the obligations to the most vulnerable populations. And that works at a level of narrative, but also works at a level of the technical solutions around litigation and policy and measures, both in developed and developing countries. And we can talk a little bit about that in Q&A afterwards.
Thank you very much, Professor Shabalala. We'll have time to do a second round so we can complete the thoughts, but we do need to hear from every member of the panel first so that you don't, thank you. So next will be online. Dr. Adejonwo, are you there?
Yes, I am. I hope you can all hear me.
Yes, we can.
Okay.
Hopefully you will stay within 10 minutes, okay? Because it's a bit hard then moderating those online.
I plan to. Thank you very much.
Thank you.
Thank you. Good evening, everyone. Good afternoon, everyone. It's a pleasure to join you from Lagos, Nigeria. It's quite unfortunate I'm unable to attend in person. But I'd like to share my thoughts, which I've titled Climate Change as an Amplifier of Social Disparities. So I'll be looking at the role of adaptation, mitigation, and loss and damage fund in Africa. So in a few minutes, I'll share my thoughts on this topic, viewed from an African perspective, but with a feminist slant. Africa is carrying an unequitable burden from the climate crisis. And this has been, reiterated several times during this symposium. It's at the forefront of the climate change impacts, dealing with the disproportionate burden, despite contributing the least to the climate change crisis. Now, the genesis of the climate crisis can be traced to historical emissions from the Industrial Revolution in developed countries. So the question is, what are some of those burdens? But before we go on to look at that, it's important to highlight that there are three main channels through which climate change can act as an amplifier of social disparity. And this is mainly through the increase in the exposure of disadvantaged groups to the adverse effects of climate change, an increase in their susceptibility to the damage caused by climate change, and also a decrease in their ability to cope and to recover from the damage suffered. And by this, I mean their ability to reduce their vulnerabilities and, of course, their capacity for mitigation and adaptation. But my discussion today will focus on the third channel. But let's just first consider the inequitable burden of the climate crisis in Africa. Now, some of those burdens include a threat to human health, food and water security, and of course, there is the threat to the socioeconomic development of Africa. But when we're talking about the unequitable burden, it's also important to highlight the economic loss that also, comes as a result of the climate crisis and the burden that Africa seems to be grappling with. Such economic loss, such as infrastructure and property loss as a result of climate disasters, increased service cost, increased insurance premium, and of course the risk to financial stability. Now, when we talk about resilience in Africa, it's important to look at it in an holistic manner. So not just building resilience to climate change, but building resilience to its economic impacts, our societies, our institutions, structures, and of course to our environment. Then women in Africa are further placed in a vulnerable position because gender norms and power structures play a critical role in determining how climate change impacts women and men of different backgrounds. So the question is, what is the importance of mitigation, adaptation, and climate finance, particularly the loss and damage fund to Africa? And then the other question is, how should the operationalization of the loss and damage fund look like? Mitigation, adaptation, and funding for loss and damage are all critical aspects of addressing the climate change crisis in Africa. And here is why each of them is important. Now, with regards to adaptation as a response to, adaptation is the cornerstone of building resilience. Adaptation involves adjusting to the impacts of climate change to reduce vulnerabilities and also to build resilience. But in order for those adaptation strategies to be impactful in Africa, it must be multifaceted, it must incorporate indigenous knowledge, there must be transfer of technology, and it's quite important for those processes to be community, or it's important for there to be community-based approaches, and of course, local approaches as well. With regards to mitigation as a response to, generally mitigation is the proactive reduction of greenhouse gas emissions. Now, while Africa's carbon pales in comparison to that of industrialized nations, we recognize our shared responsibility to curb emissions and, of course, to safeguard the planet for future generations. And sustainable development pathways that balances economic growth with environmental stewardship are quite important. Now, this can only be achieved through assistance from climate finance, such as the loss and damage funds. So for instance, or for example, Nigeria's NDC, that's its nationally determined contribution, which is a mechanism under the Paris Agreement to the United Nations Framework Convention on Climate Change, Nigeria's NDC commits to reduce Nigeria's emissions unconditionally by 20%, below business as usual by 2030. And then it also commits to reduce its emissions by up to 47% below business as usual by that same 2030. But this is conditional on international support. And of course, this international support includes climate finance and, of course, the loss and damage funds. Loss and damage refers to the adverse impacts of climate change that cannot be avoided through mitigation and adaptation efforts. The loss and damage fund is important for African countries because they provide financial support to help communities recover from climate impacts and build resilience to future climate risks. Now, the fund embodies the principles of climate justice by acknowledging the historical responsibilities of developed countries in contributing to climate change. But to fully appreciate the importance of loss and damage fund to Africa, it's important to see it from a top-down and a bottom-up approach. And by the top-down approach, this includes the policies and the programs that would guide the operationalization of the funds. And by the bottom-up approach, by this I mean it's important to appreciate the lived experiences of impacted communities and to ensure that these impacted communities or vulnerable groups, if you like, are also taken into consideration. The impact of loss and damage on livelihood of rural communities can be seen from, for example, the increasing conflict over the use of competing natural resources between crop farmers and pastoralists in my country, Nigeria. It's also evident when local women in my village of Abioye, Ogun State, share their lived experiences of climate-induced loss and damage, such as changes in rainfall patterns and, of course, the reduced agricultural productivity, which impacts their income. So it leads to loss of income. There are issues of water shortages. It exposes them to sexual and gender-based violence, although they tend not to understand that this is actually climate change and also loss and damage in action. So it's important that access to the fund and the operationalization of the fund is not complicated, such that you do not require a PhD to access it. Furthermore, funding for loss and damage should be new. It should be distinct from existing climate funds, such as the Adaptation Fund. It should be additional, it should be predictable, and it must be devoid of greenwashing. So while I do not dismiss the role of mitigation and adaptation as tools in response to climate change, it's important to emphasize that the implementation of the loss and damage funds needs to be equitable, it needs to be just, it needs to be responsive to the needs of Africa, it needs to be responsive to the needs of African women, particularly African women in rural areas, and then, of course, to other vulnerable groups in Africa. I think I have just about a few seconds.
Yeah, you do.
Okay, so.
Just one more minute.
So African states, okay, I'll just quickly round up. Thank you so much. African states need to be positioned to tap into the possibilities that are offered by climate financing, including the Loss and Damage Fund. And I do recommend that such preparations could include a resilience cost gap analysis or a needs assessment. There's a need for African countries to begin to look at standalone climate change legislations. I'm quite happy to say that Nigeria has a standalone legislation. It's Climate Change Act of 2021. But for Africa, Africa must recover and build back better from the devastations of COVID-19 and, of course, the ongoing climate crisis. Therefore, a fit-for-purpose, accessible, multilateral, dedicated fund is imperative in Africa. Thank you so much.
All right. Thank you very much, Dr. Adejonwo, for keeping to just within the 10 minutes. We'll come back to you, I'm sure, later with questions. And I believe, Dr. Funmi, you are directing your own contribution to climate-induced migration as a form of adaptation and looking at how effective that is. So we will now listen to Dr. Funmi Abioye. Over to you.
Thank you very much. I hope I'm audible.
Yes, you are.
Oh, great. Thank you so much. I'm very happy to be here with my co-panelists. Many thanks to the organizers of this symposium. I have sat riveted since early morning when I joined, so so much to learn. Yes, indeed, I will. I'm talking on the topic of climate migration as an adaptation, one of the adaptation measures that exist. So this is just a quick outline of what I will be talking about. Just quickly looking at climate migration, also looking at the AU framework. I will not dwell on that. Quite a number of speakers have alluded to the different aspects of the legal framework within the African Union. And then just focusing on climate migration in Africa, the internal migration that we are seeing that is increasing, and then also touching on external climate migration, which is really nominal at this stage, but has a potential to increase in future. And also, you know, within the conversation, looking at responses for the African continent in future. I'm just going to make this a full screen. Okay, so just quick one. Adaptation measures are basically designed, as we all very well know, to try and it's a process of change, you know, changing the way in which we do business, the way in which we live, the way in which humanity interacts with the environment to make it more sustainable and climate change resilient. So that really is the idea behind adaptation measures. When we talk about adaptation, we'll be looking at issues of, you know, livelihoods. How will farming, fishing, for example, how will those kinds of livelihoods be adapted to make them climate change resilient? If we're talking about issues of global warming, looking at, you know, floodings that we're already experiencing across the continent. And then in some other, you know, areas, we're experiencing intense droughts. So, you know, what measures do we introduce to make sure that these means and processes are actually resilient? One of the speakers, Professor Shabalala, you know, referred to the issue of technology transfer. Definitely, you know, that is one of the means in which we will be able to enhance their capacity to adapt. Another way, which I just want to quickly mention, is, you know, a law is usually rigid, and so we need to also begin to introduce levels of flexibility into the laws that we have that govern the environment, and also introducing traditional and indigenous knowledge systems into our legal systems, especially relating to environmental protection, environmental knowledge, environmental conservation. We will find, and we have found, that there is a wealth of knowledge that we have within the context of our indigenous knowledge systems that would actually help in our adaptation measures. The AU framework, I'll just quickly mention. So we do have the Climate Change and Resilient Development Strategy and Action Plan, a 10-year plan till 2032. We do have the early warning systems. The African Risk Capacity Strategy provides for this, and tries to ensure that within the different sub-regions within the continent, there's adequate provision, monitoring of developments in terms of climate impacts. Within the AU structures, there are these committees and structures that sit: the Committee of African Heads of States and Governments on Climate Change, African Ministerial Conference on the Environment has been holding now for a couple of years. There is the Climate for Development in Africa program. And then recently, just last year, there was a study that was released by the African Commission on Africa's responses to migration and protection of migrant rights. And this referred particularly to climate-induced migration, because one thing that we find when we talk about climate migration is that it's at that cross-section of migration generally that is very topical. And then also climate change in itself. So the AU study that was released last year actually made a lot of references to climate-induced migration as a means of adaptation. And of course, all of this framework we also see, incorporated in national climate change strategies that currently exist within different countries. I think, as my co-panelists, have alluded to, not all countries are on the same level. Some are playing catch up. Some have gone way ahead in terms of, developing a national framework to address climate change challenges. So migration, internal migration, climate-induced migration generally we find is increasing. And it's little wonder when we look at the kinds of natural disasters or climate change impacts that are occurring within the continent. The IPCC assessment report, the 6th assessment report, makes specific reference to climate migration in Africa. And also when we look at World Bank observations, the data that we have currently to work with tells us that in 2020, we had 13 million people who were displaced internally as a result of climate change impacts. In 2023, that number had increased to 19 million people displaced. So that's 19 million people displaced within the year 2023. It's not a buildup. And of course, the World Bank forecast has indicated that by 2050, we will be looking at potentially up to 216 million people displaced in Africa and other areas at risk as a result of climate change impacts. So what happens when, we have these high numbers of displacements within the continent? These are now internal displacements. So internal displacements in that they may be, these communities are displaced from one area or one region to another area within the same country, or might actually cross border lines and go to a neighboring state that is close to them. Usually with issues of internal displacements, especially if it is as a result of flooding, we find that people will obviously move to higher levels just to be able to escape the effects of the flooding. Last year in 2022, not last year, there was the massive flooding that affected so many different communities in Nigeria, whereby about 2.5 million people were actually displaced within Nigeria as a result of that flooding. Over 600 people lost their lives as a result of that flooding. We also had in the same 2022, the extreme case of droughts in Somalia that led to a displacement of approximately about 1 million herders and farmers. So these were people with specific, means of livelihood that were displaced. And of course, immediately, livestock, died as a result of that intense drought. So we can immediately begin to see the impacts, on food production, impacts on other areas of the society. So this is something that is occurring and, potentially will continue to worsen.
Okay,
so
Funmi, I'm smiling very sweetly right now.
Are you smiling? Okay.
One more minute, just one more minute, and then
you.
yeah.
So, thank you. So quickly, just to touch on proactive responses, and part of the proactive responses to climate migration is what is termed managed retreat. And when we, have an opportunity to come back in the next round, I hope I'll get a chance to just look at how state governments can plan ahead for managed retreats in terms of moving their communities, especially from areas that will be heavily impacted to other areas, and how that can happen in a less adverse way. But yes, I will stop here for now. Thank you so much.
Thank you very much. Thank you. We are gaining a wider view of a panoramic view from the panel across adaptation, mitigation, loss, and damage. Thank you, Funmi. And so we will now listen to Professor Olanrewaju Fagbohun to give us his take on it all. Thank you.
Thank you very much, Prof. Let me also thank the organizers and my co-panelists for the opportunity we have to be a part of this conversation. What am I addressing? To have singled out Africa for this conversation speaks volume. It means there's something about Africa. There's something missing about Africa. So I asked myself, any hope for tangible outcomes for Africa in relation to the climate change regime? Any hope? That is the question I want to explore. Now, part of shaping the law, because we are looking at shaping the law, part of shaping the law is the ability to advance the law and the ability to respond to the law. So I asked the question, is Africa in position to respond to the global climate change regime? Is Africa in position to do that? Previous speakers did so well for us since morning. They were able to identify that Africa has contributed greatly to the development. Professor Charles and others, they did so well. The consensus is that Africa contributes the least to global emissions. All of that are there. Notwithstanding, Africa remains a policy recipient and a beneficiary of assistance, as against being a partner in formulation of responses to address climate change. So I asked, what is the assumption that we are all running after, that we are following? And is that assumption correct? What is that assumption? The assumption is that the global community is interested in climate change. That is the assumption. Now, empirical evidence, how well does it support this? And I'm just going to throw up these issues because we all know them. Number one, the unsustainable debt burdens of Africa. How does that sit? Two, the EU carbon border adjustment mechanisms, which I see as a trade barrier, but has been veiled as a climate action. They want to continue to benefit from the 1.2 billion African market, knowing well that African products cannot compete with them. Number three, complex procedures. And my colleagues who on this session, they have identified it. And I say, it is not the case that Africa lacks a pipeline of investable projects, but insufficient funds, inefficient disbursement system, unfair, which I call self-serving conception of fairness. All those ones are the drivers. Of course, Africa has its own. Lack of data is a limitation. Number five, funding of adaptation relegated to the background in favor of mitigation. My colleagues have emphasized it here. What Africa needs is adaptation, but the funding is not coming to adaptation. The percentages are there for everybody to see. Number six, IP regime. And I'm glad Professor Shabalala is here. He's the expert there. IP regime does not give credence to traditional knowledge. That is what Africa possesses. So what are we talking about? I said it yesterday. Rural and indigenous Africans have always been the first victim of development. If care is not taken, they will be the first victim of carbon credits and deforestation that we're talking about. All of those solutions, they will be the victims of it. What can Africa do if Africa wants to leave the back burner and also be able to be part of this initiative? Four things I see clearly before my time runs out. Number one, Africa's approach to implementation of COP resolutions cannot continue to be disjointed. Because if you look at the policy of cohesion that Europe has, Africa does not have that kind of policy. Nairobi Declaration, when they were going, when they come back from COP resolution, in terms of short-term, medium-term, long-term plans to execute the COP resolutions, does Africa have it? And I say something, in a world where the forces shaping Africa's destiny have consistently reflected a united front to fortify their aspirations, how can individual African nations dare to cling to the illusion of isolated sovereignty as possible effective response? It is time for Africa to boldly advocate for true continental integration, wielding collective strength to shape global discourse and ensure its own destiny. If Africa is not doing that, Africa cannot face the challenges that are ahead. Number two, the fact that Africa suffered disproportionately, it is a disadvantage and it is an advantage. It's a disadvantage because of the fragility and low capacity that it has to be able to adapt. But where is the advantage? If developed nations recognize that they have been unsustainable in the way they did things, what is it that they should do? They should see Africa. If I don't want you to do something the way I've done it and do it right, I will use you as a template to show the world that this is how it should be done. And that is the kind of thing I expect in terms of impactful research, advocacy, partnership, technology. They should come in robustly. And I will use the analogy of a mentee-mentor. A mentor will say that because I've not done things in some ways, I don't want my mentee to fall into that error. If they take up that option that Africa is now a mentee of us, what are the things you expect of a mentor? Role modeling, maintain mutual respect, share your goals, active communication, constructive feedbacks, actively build trust, understand the mentee's needs, flexibility. Are the developed nations showing this to developing countries? These are the critical issues. And I said, when there is sincerity of purpose, when there is a genuine desire to make the difference, things will work for Africa. But there must be a change of paradigm. We cannot just be talking about this. The will and determination of Africa is not enough to take Africa to the promised land in relation to this issue. Promises of developed nations are also not enough. And that is where the keynote speaker in the morning advocated that we need a court to constrain people, to push people. And that was why I was pushing it. There's an adage in Africa. If people in a group, in a dancing group, don't want you to dance with them, unless they are constrained and forced to work with you, they will not dance with you. Even if you are the best dancer and the best drummer, they will not dance with you. So the situation we have, Africa will continue to be ripped unless there are rules and regulations that tightens it. The rules and regulations are there with WTO, but they are not there for climate change. Then I tell myself, developing countries must fully support climate adaptation mitigation, building resilience, because this is the only way to go. Finally, there's something that came out well for me at COP28. I think it is the loss and damage fund. Yes, people are saying that the amount that they put together was small. It doesn't matter. And why do I say that? For 33 years, developed nations ran away from supporting it, since 1991. So now that we have gotten it there, Africa needs to come together in a way that is cohesive. When there are bankable projects, investable projects, fundable projects in abundance, and just as my colleagues have stated on this panel, the rules are not unnecessarily complex for only professors to be able to assess, we will start making the difference. And when we exhaust that, there will be more money for it. Because the situation we have now is the West wanting to hold us to the same standard. And that was why the point was made earlier in the morning, that you cannot hold us to the same standard. Recognize the unique circumstances of Africa. such that when you are putting on ground the rules for assessment, if a 7-year-old and a 20-year-old are going to watch a football match and there's a fence, the 20-year-old is standing and is able to see the field. You must put a ladder there and put the 7-year-old on the ladder for him to see the field. The unique circumstances must be taken into consideration. Before the Prof rules me out of order, I'll keep my mouth shut. I'll come back to you. Thank you very much, Prof.
Thank you very much, Professor Fagbonhun. And I'm sure you heard in that weighty contribution, as I did, at least 3 voices, that of a professor of environmental law, that of a university vice chancellor, and that of a statesman coming through. Obviously, you've grappled with this for decades. Thank you for that. So now we have listened to every member of the panel, so at least we know what to expect and who to ask what questions. And I will go back now to Angela, Professor Vandenberg. Would you just then put us through what the other countries are doing? Because we got from your first round of presentation that in South Africa, case law and policy are kind of the more propellant and progressive aspects than statutory law. So now we're really keen to find out whether it's the same in other countries or it's different.
Thank you, Chair. All right, so jumping back into it and looking at Kenya. Kenya is actually leading the way in Africa as far as development of law and policy frameworks is concerned. It's the first country that developed a framework legislation for climate change, so the Climate Change Act in 2016, really trying to strike a balance between adaptation and mitigation. That sort of opened the pathway for mitigation and adaptation policies, but in particular sectors, tackling their most at-risk sectors, so agriculture, water, and energy. In 2023, they amended their Climate Change Act in the celebration of the African COP, and actually added measures for enhanced transparency by looking at carbon trade and carbon markets and trying to sort of regulate fraud in those areas. So that we're expecting will open the pathway for more litigation, which I'll get to later on. So there seems to, on the face of it at least, be a good balance between adaptation and mitigation, and the importance of stakeholder engagement in the development of their law and policy framework is really emphasized, particularly looking at vulnerable communities, so women and children. But like South Africa, there are challenges again with coordination, particularly within different ministries, looking at overlapping functions, and that has, again, sort of knock-on implications for implementation of the different legislation, particularly for those sectors that I mentioned. Interesting about the NDC, so very ambitious, but they don't have specific decarbonization goals or targets in the NDC, so it's very broad. So they too have also established different governance structures and mechanisms. These need to work with the existing ministries of industry, Ministry of Environment, similar to South Africa. And they have a climate change directorate, which really plays an instrumental role in making sure that the ministries really do speak to each other. But research has shown that it really does face constraints in terms of budget, human resources, and technical capacity, which then hampers the overall mandate of this directorate. If we then look at the stumbling blocks for the governance institutions, sorry, I've already addressed that. Then I want to just look at case law. Sorry, my slides are a bit lagging behind. So there are 2 cases in Kenya. One is decided, one is pending. The decided one is about the issuance of a license for coal power station, similar to South Africa. The court applied the precautionary principle, saying that there was no climate impact assessment. So again, reading into climate obligations. Then there's a pending one, which is quite interesting one to watch. It's about flooding, and the communities in the area that was flooded with the Human Rights Organization have approached the court seeking 12 substantive orders. So on the one hand, orders that the court must say that the government didn't do enough to prevent, minimize, or remediate any of the damage caused by flooding. but then also looking for, in order to compel the government officials to rehabilitate and relocate the damaged infrastructure, to give compensation to the victims, and to resettle the victims. We haven't seen something like this beyond in Nigeria, with the Ogoni case, where damages was provided. So interesting to see if this has a similar effect. So this really shows that the judiciary in Kenya, while there are only 2 cases, they are willing to engage in a proactive manner to hold government accountable, and then to read in government obligations where they seem to be vague. One interesting point is that plaintiffs in private cases at least have to show a causal link between damages in Kenya, and that really is a deterrent thing for communities seeking action. If I look at Nigeria, you'll see they have quite an in-depth policy framework, particularly geared at the energy sector. It's commended, though, that they have an action plan on gender and climate change, looking at women, also looking at children. So they have geared their mitigation and their adaptation actions on the oil and gas sector, which is obvious considering that their economy is based on this. They do have a Climate Change Act. It was updated recently, and it does outline the climate goals, again, also to achieve a net zero target between 2050 and 2070. But again, similar to South Africa and Kenya, implementation is lacking. A recent report, though, by the Climate Action Tracker says, looking at the legislation, that their policies are not actually consistent for their fair share or fair contribution to climate change, and they do not put Nigeria on track to meet their goals of becoming carbon neutral. So actually suggesting here that their policies are not ambitious enough, and where it is ambitious, it's not really implemented. So that's the stumbling block there. Then they do have councils for climate change governance as well. They have a Department of Climate Change, similar to South Africa, also an interministerial council. But there's a lack of ambiguity here. So here, in fact, the policies do provide for overlapping functions, but then there are power struggles within line ministries on who does what. That also can, result in a gridlock situation where action isn't taken then for climate change. 3 cases, but there are a few more just in general environmental matters, but 3 that I'd like to highlight for climate change. We spoke a lot about the Ogoni case. I'm not going to speak about that now, but I think it really speaks volumes on what the court is willing to do there when it comes to climate justice. We have the Center for Oil Pollution case, where the court for the first time expanded locus standi for NGOs representing communities. This, we think, is going to open sort of the gates for more similar class action or public interest litigation in Nigeria. So the judiciary here, in the few cases that they are for climate change, are as well very active. The length and duration, again, for climate litigation. The Ogoni case, for example, was filed in the 1990s and only had a final decision in 2018, similar for the other oil spilling case. And research is showing that the judges are very mindful of how the oil and gas sector is funding a lot of development in the country, and that may be a potential stumbling block or hamper the success of litigation. Another aspect, and I'll finish on the judiciary with this, is in South Africa and Nigeria there are parallels where the policy says we're decommissioning, we're doing certain things for phasing out fossil fuels, but then the government keeps approving fossil fuel-based projects. So even in successful court cases, implementation of court rulings seems challenging. So I think what can we say then about these countries? I think the choices behind the legal avenues that they've taken, whether it's policy, whether it's establishing institutions, are really influenced by politics, developmental objectives, and perceived climate risks, which sectors and which communities are at risk. All 3 countries do demonstrate political commitment. Their NDCs seem to be a cornerstone through which policies and laws are developed. South Africa shows an integrated approach with the economy, looking at the just transition policies of the country. Kenya is geared towards adaptation and resilience in its specific sectors, the sectors that I mentioned, and Nigeria's framework emphasized a gas transition, so looking at that pathway to energy and mitigation. But each country faces very similar challenges. So integration and coordination challenges, transparency, enforcement of laws, and again, and I think this was so well reiterated through this panel already, these legal pathways and the judiciary cannot operate in isolation. Africa needs funding and technical assistance for adaptation and mitigation. Even if we have all of these laws and they function perfectly, we cannot do it without loss and damages. We cannot do it without technical and knowledge transfer. Thank you.
Thank you very much. So could you take up on your few last thoughts from your time?
So my hope is that you'll have really hard questions for me, which are, what on earth and how could technology transfer become the subject of human rights framing and human rights claims? So I have a list of things that I'll say, and then hopefully there'll be provocations enough. So one, climate solidarity. To the extent that we see a human rights framework as doing two things: limiting who the beneficiaries are of technology transfer to those who are most vulnerable, and limiting the scope of technologies that then are subject to technology transfer claims. It allows for more pointed and direct beneficiaries to be the poor and the most vulnerable across African countries, but also with the poor and the working class in industrialized economies. We'll see how empirical that is. Two, it allows for thinking about using technology transfer claim as part of a human rights claim at the domestic level, because then it becomes a claim that poor and vulnerable people can make against the state in which they're located. But more importantly, and I think this goes to the argument around policy space and policy freedom, it allows for developing countries who are seeking to change their policies to address the needs of the most vulnerable to use that as a justification for varying or even perhaps making conflicting policies that might conflict with their duties and obligations under the TRIPS agreement, or at least to justify expanding the use of things like Article 66 and Article 8 under the TRIPS agreement for meeting the needs of their own populations. And so using that fairness and equity argument, the human rights argument, to say, get off my back, I'm doing this to address a human rights need, not simply a mercantilist need. Along with that, I think there's some potential litigation strategies beyond the domestic level for that as well. I'll leave it there. I have others, but.
Thank you very much, Professor Shabalala. So I think at this point, because we are really having to be very creative in our use of time, we will open up to take questions, and our colleagues online, if you have other things to say, you can fit them in as you answer the questions, okay? Drs. Abioye and Adejonwo, is that okay?
Yes, it is.
Okay.
Thank you.
Thank you very much. So I'll open up now to the floor. Anyone with specific questions for our panelists? Okay, see your hand there.
Thank you very much. My question is prompted by Angela's presentation, but I think it's a question that others might also want to come in on. So if we look at some of the domestic cases that you considered, and considering jurisdictions that have broad standing and access rules to bring such litigation, and where there's justiciable bills of rights and good domestication of international law, do you think that defending such actions might become a restraint on the arguments that the state is willing to engage in on the international plane as regards their obligations in international law? So does it in effect then become a stumbling block to advancing a sort of more liberal agenda at the international plane?
Is your question for anyone, for the panel? So would you like to go? Angela?
I do think it was a challenge to you, right? Which
you
is
start. Angela, you start.
Are you saying that the act of this role of the judiciary would... I'm not sure I understand your question.
What I'm asking is, if in the domestic space, there are very clear space for litigation against the state, that in
I hear you, I think that's a very valid concern. If South Africa is being ambitious in terms of Paris Agreement or UNFCCC, and then legislating their ambitions through via their NDC, and courts are holding them accountable, of course then they might rethink and think, oh well, we're a non-annex country in any way, let's be less ambitious because our courts are reprimanding us or tapping us over the fingers too much. Not an angle I've thought of yet, but very, very interesting. I do agree that that could happen. You have thoughts on it too?
So I think it has to be a bargain, right? That, yes, you will get into potentially more trouble at home from your own citizens, but perhaps what this will allow you to have is a cudgel you can use against other countries when they fail to provide you with the operating and policy space to address those needs. So, it's how I've thought about this technology transfer issue, which is, to the extent that it gets incorporated as a demand at the domestic level, it also becomes a way for countries that are saying, okay, out there, we are going to have to be careful about which new technology transfer technology obligations, IP obligations we take on, which we definitely want. But also they'll be able to use that to say, and you are obligated to assist us in meeting these human rights needs of our populations under Article 2 of the ICSR, under broader committee requirements, and being able to use that demand and strengthen again, I think, what has been a very weakened equity argument in these arenas, I think would be good. That knowing that they would now have access to the equity argument that they have not necessarily had access to before, I think would be really helpful. And that equity argument is only strengthened by domestic litigation, I think.
Right.
If I'm going to add to that, I'll go back to the session of Professor Charles and what Prof said in the morning. In terms of what they did, they took us back to the vision of people like Nkrumah, vision of people like Azikwe. And why were they pushing that? That there's a need for integration. You will say that assuming Africa is effectively integrated, these issues that we are talking about at domestic levels will not happen. Because it is because they are not integrated. That is why you see that there are always gaps in what one country is doing vis-a-vis what another country is doing, and these gaps are exploited from time to time. Cohesion brings all of this together, which is why what Africa needs to do is to be able to stand up and say cohesively, this is who we are. These are the challenges facing us. And I'm now stepping back into one or two other areas of energy challenge for Africa. Without cohesion, we cannot face it. Only 40% plus in Africa has energy, has access to energy. When you have a deficiency in energy, it is poverty of even feeding yourself. They said it in the morning, it's like taking bread out of the mouth. The minister said it. It's like taking bread out of the mouth of the child. When you don't have energy, there's an adage that a poor man is hungry, and you are telling him about environmental sanitation. You're talking about climate change. When people are hungry, it's not going to happen. So there's a need for us, and that is why this separation of trade from climate change must stop. They are one thing. It is integrated. We must work together on them. Not that you are benefiting, you are using one hand to benefit from trade, and you are telling me not to use my fossil fuel. We have to be careful about the way these narratives are pushed. Thank you.
Thank you very much. So while looking around to see if there's any other question, I've got a few to kind of tie things together, and this is looking at adaptation and wondering how effective as an adaptation measure migration is. And I think this is more Dr. Abioye's focus, but anyone on the panel can take up on it. Under what conditions do we interpret or describe climate-induced migration as beneficial as an adaptation measure? How do we mitigate the losses in terms of human capacity, economic and otherwise, suffered by the home country as a result of climate migration? And what are the proactive steps which African countries need to take to harness the potential benefits of this kind of migration. And I think you've mentioned a few steps already, Professor Fagbohun, the cohesion that is needed, the integrated analysis and examination of themes. So these are the questions I've just thrown open for any member of the panel or any member of the audience to speak to as we enter the wrap-up portion of this panel.
If I may.
Yes, go ahead.
Okay, thank you so much. And I think, it will just help me also to just, just touch on the aspects of my presentation that I didn't touch on. So basically, when we look at under what conditions, we can begin to look at climate migration as being beneficial, because we're actually talking about displacement-induced migration. We're talking about migration that is more or less forced. It's not something that is necessarily planned. One of the approaches that is proposed for African states to begin to look at is to using the early warning systems and the data and information that come from early warning systems to begin to have a proactive approach to planning ahead. Because the early warning systems and the information will already tell us that flooding will happen, and these are the low-lying areas that are more susceptible to flooding, for example. So how do we, within African states, in the local government areas, actually plan ahead for that kind of flooding? And so when we looked at the issue, the aspect that I touched on earlier in terms of managed retreats, that is one of the ways in which states can plan ahead and move the vulnerable members of communities, even if the entire community cannot be moved, to better or higher level areas, to move those communities to areas where they will not be susceptible to such floodings. Because, and this is proposed really as an extreme. If adaptation measures are successful, then we may not necessarily have to consider managed retreat. But as we have heard, loss and damage is intensifying because we cannot catch up. Even the measures that we're proposing, we don't even have the necessary funding for these adaptation measures currently. Meanwhile, global warming is going to get worse. Potentially the risk and the impacts will get worse. So we need to begin to think ahead, to move, in this instance, those kinds of communities. Another way that, we can begin to interrogate these kinds of impact is what we have existing under the ECOWAS climate change strategy. And I'm very grateful Professor Fagbohun has actually touched on that aspect of integration, because as long as African states do it singularly or want to do it singularly, we will not get far. And so within the climate change strategy that we have in ECOWAS, which is a 2022 document, there's a proposal that ECOWAS member states must have a unified approach, especially to the issue of climate migration, meaning that those states that are going to be heavily impacted by, by climate and by flooding or even droughts must be able to interact with member states and have some kind of agreement in terms of moving communities even across state borders, because that is the reality that we are fast approaching, and that is what is going to result in. Quickly, and just as a last word, I just want to touch on the issue of external migration, because climate migration is not only internal. External migration is forecast to increase, especially in the light of increasing numbers of migration internationally. So we will continue to see an increase in Africans moving out of Africa as a result of climate migration. So some of the approaches that we have seen in other among, just approaches across the world, the issues of policy. When we talk about humanitarian visa regimes, why do we not, or why can we not include something like climate impacts, or those who have suffered displacement as a result of climate impact in those kind of humanitarian visa regimes, so that it's not just violence, it's not just some kind of gender-based persecution that we have within those kinds of regimes. Argentina currently has established for Mexico, Central America, and the Caribbean a three-year social and health benefits regime, whereby nationals from those countries that are impacted by climate change are actually allowed to come into Argentina for 3 years and are beneficiaries of, all this kind of social benefits. So we need to also begin to look at introducing those kinds of regimes even within the African system and globally. There's also labor migration programs that are existing in some regions of the world that we can look at, so that when people are displaced, they are not just rendered redundant. They are not put in camps whereby their human dignity itself is affected. What happens when people are displaced and they are taken to other communities or other states? Is there a way in which they can be integrated, even if temporarily, into the labor force, into the labor markets of those societies? And then lastly, just looking at what kind of benefits on the community that has lost these numbers of people as a result of displacement. Then we begin to look at issues of remittances, diaspora remittances. Is there a way in which to harness this kinds of volumes of money that already we know is flowing back to home countries, but is there a way in which to harness this kind of remittances to begin to think proactively to use as some kind of build back mechanisms in the home countries that have suffered as a result of displacement? So those are some of the things and points that I just want to throw in the mix in terms of, the approaches of African states and the benefits possibly that could arise as a result of climate-induced migration. Thank you. And I hope I answered your question, Prof, in the process.
Right. Thank you. I'm sure that you did. Thank you very much, Dr. Abioye, for that intervention. So I think we've come to the end of this panel. We've gone way beyond time. But thank you for your patience to the audience in listening and in cooperating with us. And hopefully we have been able to throw out persuasive thoughts on the subjects of adaptation, mitigation, loss, and damage. Thank you to the eminent panel, and we'll have to clear for the next panel. Thank you.
Thank you so much. Thank you very much.